Ladies and gentlemen, welcome back to the Indie Zone. My name is Kathy. On September 3rd, 2025, Judge Stephen J. Hippler rendered 3 court orders regarding the dissemination or possible non-dissemination of documents that have been under seal from the public in the case styled as Idaho versus Kohberger. One indicated that certain documents would not be unsealed. A second indicated that other documents would be unsealed with no rejections. And a third indicated that certain documents would be unsealed but with redactions. If you have not had an opportunity to review those documents, I recommend that you do, because it will provide you with further details regarding the document that we're going to go over right now, which is a document that has been released to the public. It is dated June 27th, 2025, and you can see on the upper right-hand corner of this document and all documents that are on the public docket the date of filing by the clerk of court on the public record. This particular document was filed by the clerk on June 27th, 2025 at 10:22 a.m. What it is the defense's second notice of filing defendant's additional objections to the juror questionnaire under seal. It reads as follows. Comes now, Brian C. Kohberger, by and through his attorneys of record, and hereby submits to the court the defendant's additional objections and additions to the jury questionnaire received in court on June 18th, 2025. And if you go to the next page of this document, you will see the additions and or objections that the defense was raising to this juror questionnaire. They appear to be several questions dealing with the ultimate penalty that Mr. Kohberger could face if the jury returned a verdict of guilty at the jury trial that was scheduled to commence later in the summer of 2025. That, of course, did not happen because just days later, Mr. Kohberger stood up in open court, as he did on July 2nd, 2025, and pled guilty to all 5 of the criminal counts that he was to stand trial for. And they are listed in the indictment that was returned by the grand jury of Latah County against him in May of 2023. If I could point out a few further observations regarding this document. First and foremost, if we look at paragraph 1, page 1, it states here that this jury questionnaire was received on June 18th, 2025. So it appears that at that time, this is when this jury questionnaire was in its final format. The jury questionnaire and everything dealing with the jury questionnaire was directed by Judge Stephen J. Hippler back in late 2024 when he rendered the order that set the jury trial and voir dire. Voir dire is the process of jury selection, and this jury questionnaire was a tool to assist in the process of jury selection. We know that everything having to deal with the jury questionnaire was under seal while the case was pending, because anything that was filed under seal. The other point that I wanted to raise for you is that this is stated as additional objections and additions, so it appears that there was another document that was filed by the defense. By a pure read, the four corners of this document would suggest that, because these are set to be additional objections and additions that the defense is making to whatever was filed previously regarding additions and objections. But the major point that I wanted to raise at this time for you is look at this date of filing. This is filed the morning of June 27th, 2025. So at this point, it stands to reason that the defense was still actively preparing for trial to the point where they are adding additional objections and additions to the jury questionnaire that would be used for voir dire purposes, which was scheduled by operation of Judge Hippler's order 2 days later. According to the court records, Mr. Kohberger had completed a 9-page document that was the Guilty Plea Advisory Form. And then, a couple of days later, he stands up in open court and pleads guilty, which cancels the jury trial that day. So the question is, what was it that happened within 48 hours that caused the defense to suddenly change course, go from, for over 2.5 years, stating that Mr. Kohberger was not guilty, but also at certain points to say that he was factually innocent? Different than saying that a client is not guilty because the other side lacks evidence to prove him guilty to 12 jurors in a court of law beyond a reasonable doubt. These are opinions that I give relative to the First Amendment of the United States Constitution. Comments, speculation that I'm making, nothing based on facts. I have no inside information as to what was going on behind the scenes with the defense and the state that led to this complete change in strategy just days later. If you have any comments, any thoughts, any opinions, please leave them here. And until next time, this is Kathy. Thank you very much for joining us here today.